through practical engagement with a commitment to quality. If I too may be allowed to quote Robert Frost, two roads diverged in a wood, and I, Member Secretary Nalsa, to kindly propose the formal vote of thanks.
Hard days of intense discussions spread over 4 working sessions. It's not time, and those whose planning has made it possible. It's my proud privilege to do so on behalf of the National Legal Council.
Man is not made for law. The law is made for man. Access to justice allows people to have their voices heard, exercise their rights, challenge discrimination, and hold decision makers accountable. Access to justice as a basic principle of the rule of law necessitates provision of fair, transparent, effective, non-discriminatory, and accountable legal services that promotes justice without consideration of religion, race, caste, sex, place of birth, or any other similar extraneous consideration. Paris Committee, 1950, the First Law Commission, 1958, were constituted to look into the matter of provisioning of legal aid. A common recommendation was that legal representation should be made available at state expenses at the discretion of the court after ascertaining various factors, including means of the petitioner, the criticality of the matter, etc. However, recognizing a perilous gap, the Supreme Court, as early as in 1951, when there was virtually no national discussion on legal aid, in the case of Janardhan Reddy versus State of Hyderabad, stated, I quote, where a litigant is disabled from accessing justice on account of poverty or otherwise, such a situation would amount to a negation of fair trial. Article 39, Capital A, further brought to the forefront what till then had been a topic of limited relevance for governance, mandating that the state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity and to ensure that this opportunity is not denied to any citizen by reason of economic or other disabilities. How crucial the right to fair trial became after that can be understood by following the evolution of this right. By the 1980s, this right had come to be recognized as an intrinsic part of Article 21. Such recognition metamorphosed the right to fair trial and by corollary access to justice into an integral component of the basic structure of the Constitution. Inalienable, unamendable, and transcendental. This constitutional right is therefore beyond the transit pulses of elected governments, unamendable even in the exercise of parliamentary sovereignty. It is no longer a matter of largesse by the state. It is a matter of right that inheres in every citizen to have access to quality justice. Of those who seek it is a constitutional promise. In fact, it's a constitutional mandate. Whether we have been successful of access to justice. The underlying theme animating the idea of access to justice is to promote an all-inclusive legal system aimed at empowering the vulnerable and disadvantaged sections who often exist on the margins of the society. By securing to them rights fundamental to a dignified living. This is achieved through the means of free legal aid. Justice P. N. Bhagwati, as the chairperson of the Legal Aid Committee, had observed and if you permit me, I quote a few lines. The legal aid means providing an arrangement in society so that the machinery of administration of justice becomes easily accessible and is not out of reach of those who have to resort to it for enforcement of the rights given to them by law. The poor and illiterate should be able. Next that I would like to stress on is technology and access. Technological innovations must be embraced in all aspects of functioning and professionally managing rendering of legal services at all levels. This would ensure timely and effective reach of services to the needy. Utilization of technology would also help streamlining the process of delivery through customizing legal services as per the needs of the people and help identify bottlenecks. If I may, I have one or two suggestions in this regard. Let us use technology to provide greater information about legal aid through mobile apps similar to Nyaya Bandhu and Telelaw. This should be especially in vernacular languages. Providing vital information to those seeking legal aid about the status of their cases and applications, and above all, to map areas with similar social legal issues or comprising of marginalized sections of society having similar legal issues. Impact and accountability is the next area I will touch upon. Good numbers are not enough. In fact, there is no better mirage than statistics. It is therefore important that quality is given as much attention as quantity of legal services. Right to legal aid means right to quality legal aid. Commitment to quality must permeate the whole organization. I have a few suggestions again in this regard. There should be a rigorous selection process for empanelment of lawyers. If need be, their selection could be made on the lines of the process followed for selection of public prosecutors. This would go a long way in addressing the complaint of lack of quality. This can, to a large extent, also be achieved by addressing concerns of adequate economic incentive. Currently, it is often told to us that good lawyers keep away because of low and untimely payment of honorarium. That's one of the reasons. Building up a committed cadre, selected through a transparent and rigorous process, would form a very persuasive argument to enhance and ensure timely payment of honorarium. Enhanced and regular training should be provided to build capacity among panel lawyers and paralegals. To provide quality training, the state legal services authorities must partner with the state judicial academies or the national law universities and other universities to evolve a comprehensive, innovative and pragmatic training program. What is the road ahead? I find that the identified topics that had been listed for discussion during the meet are indeed pertinent for expanding the reach of legal services in the country. It is heartening to witness that NALSA and the state legal service authorities have attempted to build upon its past virtues. However, as Robert Frost had said, but I have promises to keep and miles to go before I sleep. It is in that spirit that permit me to outline some points for your kind consideration. Legal literacy is the first aspect that I would like to touch. Awareness of one's rights and means of securing those rights are powerful instruments for bringing about social and economic progress. Absence of legal awareness is the root cause for deception, exploitation, and deprivation of rights and benefits of the masses. Legal literacy and legal awareness go hand in hand. The legal aid movement cannot achieve its goal so long as people are not aware of their basic rights. Greater awareness translates into better and broader access. Today, legal education in a large measure is limited to universities training future lawyers. Though education on legal topics are included in schools and college curriculum, it should go beyond rudimentary awareness. What is instead required is movement from mere awareness to engagement, use of legal knowledge to do good. Efforts must be made to secure concerted engagement of young minds in understanding and utilization of that knowledge for the benefit of society. NALSA and the state authorities must focus its energy and efforts in imparting legal literacy to young people. Further, students from schools and colleges, and not just law colleges, must be involved in the outreach programs organized by the state legal service authorities. That their talent must be utilized in a meaningful and creative way, be it to develop short video and audio documentaries about rights working of various socially relevant legislations. Students and young persons have the potential to become ambassadors of justice. That potential should be tapped. The paralegal volunteer scheme may be enhanced to give effect to some of these suggestions. Must take the lead in the matter and ensure that such and similar linkages are evolved at the earliest. I have come almost to the end of my address, and in conclusion, all that I would like to say is, legal services must be construed to achieve distributed justice, effective implementation of welfare benefits, and elimination of social and structural discrimination against the poor. The NALSA and the state legal services authorities are crucial vehicles for discharging a constitutional mandate, namely justice to all on the basis of equal opportunity. These bodies have to in turn ensure that through their efforts, justice reaches to the remotest corners of the country and to the last person residing there. As we ponder upon the implications of some of the conclusions that must have been reached, this meet, I am confident, would have and would lead to generation of innovative ideas and thoughts that could be utilized to ensure justice for all, which in turn would go a long way in securing a more comprehensive and accountable governance. It is my fervent hope that the valuable inputs received over the last 2 days would be utilized meaningfully by the NALSA and the state legal service authorities in their future endeavors. This year, we are celebrating the 158th birth anniversary of Mahatma Gandhi. It is therefore only appropriate that we turn to the father of the nation for further guidance, who once said, I quote, "The first step to achieve justice is to make injustice invisible. The first step to achieve justice is to make injustice visible. Pursuit of justice must involve elimination of injustice, and it is unjust that anyone is denied the opportunity of pursuing their right owing to poverty. I hope that the conclusions drawn in the 17th All India Meet will help in meaningful alignment of planning, program designing, and service delivery of NALSA and the state legal services. with the fulfillment of the constitutional promise. Thank you, brothers and sisters judges. Jai Hind.